Good afternoon, everyone. Welcome to Public Safety and Security. With that, we do have enough members currently present for quorum to begin, so we're going to go ahead and begin. Ms. Dory, will you please take roll?
Assembly members Cole, Considine, present. Dahlia, here. Gonzalez, Gurr, here. Hanson, Hardy, Karras, here. Marzola, Moore, here. Orentlicker, here. Patchett, here. Roth, here. Yeager, here. Chair Miller,
here. And please mark additional members present as they arrive. Thank you so much. So welcome to everyone here in Carson City, as well as anyone that would be joining from Las Vegas, and of course anyone watching on Nellis or our YouTube station. As you see, before we go any further, we have a special guest member today, which is Speaker Yeager, who is technically a member of every single committee in the House anyways. So he is joining us today for this hearing. With that, just a few reminders that asking you to turn down the volumes on your electronic devices as so not to be disruptive during the process. As stated, the agenda is on Nellis, and you can also watch through Nellis. We only have one bill on the agenda today, and that is Senate Bill 8. We ask that as you're speaking today that you make sure that you speak into the microphone, and we ask all speakers, whether you're a presenter or testifier, to make sure that you state your name, spell your name, and any affiliation you may have. For the presentation, presenters will have, we always ask that you keep your presentation to 15 minutes. And anyone testifying, we ask that you keep your testimony to 2 minutes each. I will provide an hour of testimony for those that are in support of the measure, an hour for those in opposition of the measure, and an hour for those neutral in the measure. Again, I'll remind folks before we begin, because neutral is often an area that is confusing for individuals, but neutral is when you're not taking a position on the bill one way or the other. You may just be addressing or explaining certain impacts on that the measure would have. If you're not able to communicate all of the statements that you have within your 2 minutes, we definitely invite you to submit it to us in writing. You have up to 24 hours after the adjournment of today's meeting to do so. Again, you'll see committee members on laptops and other forms of electronics. Please do not take this as an indication of that they're distracted or not paying attention. It's the way that we're working, researching, and communicating. And so with that, we'll go ahead and begin with the first item on our agenda, which is the hearing for Senate Bill 8. So I will open the hearing for Senate Bill 8. I will invite the presenters up to the dais. Hi, I'll give you a few moments to get settled in, and then whenever you are ready to begin, please each speaker state their name, spell their name, and then please remember as you're speaking to restate your name before you speak again, and you will have 15 minutes. So whenever you're ready, please begin.
All right. Good afternoon, Chair, members of the committee. Paul Moratkin, M-O-R-A-D, KHAN, Executive Vice President, Government Affairs for the Vegas Chamber. Thank you, committee members, for your time this morning. Our intention today is to clarify what SB 8 does. The very premise of this bill is to maintain the legal environment that we believe that has existed for decades for employers and employees. The decision by the Nevada Supreme Court, as you can imagine, has caused confusion and concerns for Nevada's employers, both small and large. And that is why the Chamber of Commerce approached legislative leadership and the governor on behalf of Nevada's entire business community. This bill affects all businesses, all sectors. It is not for one business, one sector, or one company. It is for all our employers. They're the economic engine of this state. Each of you, as you know, have small businesses in your district. They're your friends, neighbors, and constituents. They make your district better by creating good-paying jobs for your constituents. As you know, small businesses are the economic engine of the state, and they create the jobs and provide Nevada's workers with financial stability and for livelihood. As you have heard from this chamber and from our trade association partners, employers need a legal and regulatory environment that is stable and predictable. That is our intention, to correct that confusion that is created by the court ruling. It is the Chamber's belief that this bill basically maintains the status quo. We have worked with other representatives, including some from labor, to ensure that we do not take away any worker protections, and literally keeps the legal environment the same following the Supreme Court decision on October 30th. As you know, the courts have been very busy. I will now turn it over to Paul Trember from the Jackson Lewis from the Las Vegas office to walk through the bill. But I just want to clarify one other component. This bill preserves the employee's ability to come to work early, to socialize, if they wish to organize and attend those meetings with their union reps. This bill changes nothing. With that, I will turn it over to Mr. Trember for his comments about the bill and overview. Thank you, Madam Chair.
Hi, my name is Paul Trimmer, Trimmer. I'm a partner at Jackson Lewis. I practice in Las Vegas. I'm here today representing the Nevada Resort Association. In Amazon Services versus Malloy, the Nevada Supreme Court addressed a question about the legislature's intent in Chapter 608 that had been certified for it by the U.S. District Court for the District of Nevada. Specifically, the question was, does Nevada law incorporate the exceptions to compensable work that are laid out in the Portal to Portal Act? The court answered the question in the negative. This bill is intended to address the impact that court's decision has on both employers and NRS Chapter 608 statutory scheme. It reflects the legislature's long-standing intent to incorporate federal law, the Fair Labor Standards Act and the Portal to Portal Act's exceptions to compensable work, as well as clarify the manner in which Chapter 608 calculates overtime compensation rates. The legislature, employers, and employees in this state have always understood Chapter 608 to incorporate those principles established by the FLSA and the Portal to Portal Act. The court recognized as much, and by the court I mean the Nevada Supreme Court, when it observed on page 5 of its decision that Nevada wage hour laws mirror those found in the FLSA. Employers in Nevada have relied on the applicability and interpretive principles found in those analogous federal statutes. And there are some aspects of Nevada law which are significantly different from federal law, and that's always been clear. 608-160 has very clear language about how employee tips are maintained and kept by the employees who receive them. That's different than federal law. 608-018 contains a daily overtime requirement, again, not present in federal law. But in areas where Chapter 608 is silent, just as there are many areas in Nevada law where this legislature has spoken and there are also gaps, employers have always relied on federal law to fill in those gaps and determine what their obligations might be. And in those cases, they've relied upon the FLSA and the Portal to Portal Act. The bill before you today reaffirms the longstanding intention of this legislature to incorporate the FLSA and Portal to Portal Act's provisions which exclude certain activities from compensable time. And looking first at Section 1 of the legislation, or of the proposed bill, it amends NRS Chapter 608-016, which determines when employees shall be compensated. And it references both the FLSA and the Portal to Portal Act and specific regulatory provisions within that are attached to the FLSA as to illustrate those situations where employees will not be compensated. That includes attendance at lectures, meetings, training programs, and similar activities if those are both outside of normal hours, they're voluntary, so they're not required by the employer, and they are not related to an integral and indispensable activity of the job, and no other work is being concurrently performed. And that's Section 785-27 to 32. It also adopts the FLSA's definitions of compensable and non-compensable travel time. That's the reference to 785-33 through 785-41. It adopts the FLSA's definition of compensable versus non-compensable on-call time, and that's 785-17. It adopts the FLSA's definitions of compensable versus non-compensable waiting time. It adopts the FLSA and the Portal to Portal Act's approach to donning and doffing, which is the legal way of describing changing clothes. So these are all examples of situations where employers have relied upon federal law to determine what their obligations might be. And especially when it comes to the Resort Association and hotels in Las Vegas, a huge amount of customs and practices have evolved around our understanding of what federal law, state law by incorporating federal law requires. So just to give a couple of different examples, in a situation where any security check could be compensable, it then turns to the next step in the next part of the analysis, which is called the continuous workday. Once an employee performs any compensable act, every minute thereafter is compensable. So if walking into a building, going through a security check is deemed to be compensable time because it's related to getting into the building and because it's a security check, so it's under the control of the employer, every minute thereafter has to be compensated. You can't compensate just for the check and then take them off the clock. That doesn't work. That's not the law. It's not the law in Nevada, and it's not the law under federal law. And if employees or employers are required to start the clocks for when employees go into the building, it's going to mean that many services and things available to employees in the back of the house of a resort, we can't offer those things anymore because they're not going to be off the clock. So for many employees come in to work 30 minutes to an hour early. They take advantage of free laundry services, even though they have uniforms that they can bring home. The employers often clean them for them, and they take advantage of that. There are gyms in the back of the house. There's free food at the employee dining room. They engage in protected concerted activity with their union representatives. They socialize. Every one of these resorts on the Las Vegas Strip is kind of like a little town with somewhere between 2,000 and 6,000 citizens. And much of the civic life of that little town takes place off the clock in the back of the house. And because the Nevada Supreme Court answered this incredibly broad proposition of whether or not they weren't answering the question of whether or not bag checks for Amazon employee or security health checks for Amazon employees as set forth in Malloy, they weren't answering whether that was compensable. They were answering a hypothetical question of whether or not Nevada law looks to federal law for interpretation and guidance. And that's the thing that has to be addressed by the legislature. That's what this bill does. It answers that broad question. It says, yes, Nevada law does look to federal law. It incorporates those principles. The particular case for Amazon, that's still in federal court, and that's for that federal court judge to decide. This case, or this legislation, answers only what might be required under Nevada law. Section 2 of the proposed legislation incorporates the FLSA's methodology for calculating the regular rate. It's included because, again, the regular rate is how you figure out how much overtime compensation someone is entitled to. It's 1.5 times. But there are different parts of your compensation that are included when you're figuring out what 1.5 times is. Normally, it's just your straight wage rate. There are some situations where plaintiffs' lawyers have tried to claim that the value of employer-sponsored benefit plans, so like the value of the employer's contribution to your health insurance, should be included when calculating how much overtime compensation you're entitled to. No employer in Nevada uses that methodology. I'm not aware of any state in the union that utilizes that methodology. But because there's a gap, because the statute is silent, and the interpretive analysis that that the state Supreme Court used in Malloy could be used in this situation, we have included that in our proposed amendment. Last is Section 3 of the proposed statute, and that makes it clear that the Malloy decision is rolled back as if it didn't apply. So it ensures that employers in Nevada continue to operate under the long-standing reason-based belief, good faith belief that their obligations are those that are dictated by Chapter 608 and federal law. And that's the proposed amendment. It's pretty narrow, but it's intended to address just this decision that was issued by the state Supreme Court. And I'm here today to answer any questions you might have about more specific things.
Thank you. Good afternoon, Chair, Vice Chair, committee members, and Mr. Speaker. My name is Virginia Valentine, and I'm here on behalf of the Nevada Resort Association. On behalf of our 72 resort members, we are in strong support of SB 8, and I should say in addition to our 72 resort members, our employees and all of the small businesses that provide the goods and services that make it possible for a resort to exist. As you heard from the presentation, for decades, Nevada employers have relied on a clear, consistent, well-settled understanding of past practices based on federal and state case law regarding pre- and post-shift activities. This framework has guided employees' policies, employee expectations, and operational practice in our industry for years. It's so ingrained in our facilities that the structural facilities of something like an employee dining room are specifically set up to encourage employees to come to work, to socialize, and to do many of the activities I'm about to talk to you about. To limit ourselves from this wholly unanticipated and unacceptable legal risk, in addition to potentially catastrophic monetary exposure, Nevada employers may be faced with no other option than to establish controls to prevent employees from accessing the workplace until their start time. For example, employees who currently choose to arrive to eat a complimentary meal in the employee dining room, the EDR as they're known, before their shift, or who stay afterwards to eat or socialize, would no longer be able to do so. For example, many employees depend on public transit or rides with family members and coworkers. They routinely arrive early or wait until their shift ends. The everyday activities they've grown accustomed to would be eliminated or limited. This change would also affect the access to on-site human resources, uniform services, employee services, complimentary health and wellness assistance, or other free benefits that are provided on the property, and these are widely and robustly used by employees. Resorts have long provided clean press uniforms on site, free of charge, including specialty garments that require professional care. This practice would have to end, resulting in new costs for employees to launder, maintain, and transport their own uniforms. The locker rooms and changing areas may be forced to close or significantly reduce access. Without legislative clarity, employers will be forced into making these restrictive, impractical, and costly operational changes that would eliminate flexibility and degrade the supportive workplace environment that Nevada resorts are known for. We cannot overstate the severity of the consequences that will occur should decades of past practice and long-established customs that our industry has followed in good faith be undermined. For these reasons, we strongly urge you to pass this legislation to preserve the long-standing workplace framework that has supported our workforce and our industry for many years. Thank you for your consideration.
Thank you. Does that conclude the presentation of the bill?
Yes.
Okay, thank you so much. Then we will begin with questions. Our first question is from Assemblymember Cole.
Thank you, Chair. Thank you for the presentation. So my question is related to the concept of status quo, thinking everything is status quo. So can I ask for you to confirm on the record that the status quo means that SB 8 will have no impact to any judgments that may have already been awarded, given the amendatory language that's in Section 3, and that there's no change or upset to any pre-negotiated union contracts, and no change to any benefits rights that employees currently have? Thank you.
Paul Trimmer for the Nevada Resort Association. That's correct.
Thank you so much. Our next question is from Speaker Yeager. And of course, Speaker, you have the liberty of the floor.
Thank you so much, Chair, and thank you for allowing me to participate. I think my question is for Mr. Trimmer. Well, first, let me make a statement. I think this happens quite a bit in the legislature, where we get an opinion in between legislative sessions from the court that requires us to decide whether we're going to enact legislation or not. It can be pretty frustrating for us because we're very part-time and we rarely meet. Just so happens that we're in a special session right around the time that this opinion dropped. And so I guess the question is this. Mr. Trimmer, I'm sure that you often counsel clients and employers about what to do in these sort of circumstances. And I'm sure, like a lot of attorneys, you probably have a network of other like-minded individuals who act, who are in this space of employment law. So I guess the question is, I assume that historically you would have thought the federal law would apply, and that would have been your guidance to your clients. When this case was certified, I guess, to the Nevada Supreme Court to answer the question, did your thoughts on that change at all? Was there kind of a, I don't know, I guess, was there caution in the employment law bar that, the court might do something unexpected here? And so I guess I'm just trying to get a sense of like how much, and I don't want you to criticize the court because I know you're an attorney and you practice, but like how much of a shockwave and an unexpected result from the Nevada Supreme Court was this for folks who have operated in the space that you operate?
It was dramatic. And sorry, Paul Trimmer for the Nevada Resort Association. I'm new to this, I apologize. It was shocking. And although there has been litigation about this exact issue for years, the Nevada Supreme Court itself has always been very clear that even when a federal court speaks to what a Nevada statute might mean, the Nevada Supreme Court is the final decision maker. So for example, for the last 10 years, we had litigation over whether there was a private right of action for overtime, whether or not there was what was the length of the statute of limitations for a minimum wage claim under Nevada law. And not surprisingly, even the U.S. District Court for the District of Nevada issued several decisions dealing with all of those issues. But when those issues came to the Nevada Supreme Court, such as in the terrible Herbst case a few years ago, it can't be overstated how strong the Nevada Supreme Court was in stating, we decide what Nevada law means when it comes to these types of issues. So the fact that a federal court had considered some of these issues in the past, such as the Sixth Circuit, that wasn't terribly concerning to many employers because the Sixth Circuit, hearing a case in multi-district litigation, I know that's a little bit detailed, has no authority over Nevada. It had authority over Amazon and the litigants in that case. And so when it comes to not just whether or not a particular type of security screening or health screening is compensable, but to this general proposition that Nevada law does not embrace federal law, that was shocking, absolutely shocking, because, for those of us that have grown up here, and I've practiced here, I grew up here, I practiced here my entire career, Chapter 608 contains a number of very specific requirements for Nevada employers. And those requirements, like I said, daily overtime, tip credits, or the absence of a tip credit, they reflect very specific decisions from this legislature about what Nevada employees need. But the fact that this legislature hasn't spoken to something does not mean that it rejected federal law. That the absence of enacting federal law was a complete rejection of what federal standards are. And that's what the Malloy decision, that's the holding in that case. And that, I couldn't disagree with it more as a practitioner. And I understand that they're the final decision maker, but that means that this issue needs to be clarified.
Thank you. Our next question is from Assemblymember Hardy.
Thank you, Chair. Thank you, excuse me, for being here. And I just wanted to ask, obviously, with the amount of employees that are in large resorts and stuff, this could have a huge impact. So could you just share maybe the impact it could have on, say, small businesses as well? Much fewer employees, but could still have quite a significant impact if we didn't have this legislation. Thank you.
Paul Moratkin, for the record, through the chair to Assemblymember Hardy. That's a great, thank you, Chair. That's a great question. Their liability would be the same as a larger member, right? The difference is those a small business, they have smaller resources. If there is instability of what could happen to a small business in the legal environment, they could be put out of business by a single lawsuit. That's the reality of it, right? I mean, that's not a hypothetical, one lawsuit does shut down a business, small business, if it's a micro business, if it's a family-owned business. Those are the neighborhood businesses we're talking about here, right? And, in conversations we had in the last few days, small businesses, as you know, have very limited resources. They do not have Mr. Trimmer here on retainer. They don't have those resources, as you know, as a former business owner, selling member. So, I mean, to change the premise of how it's been operating and so forth, to tell that small business that's typically family-owned, and they have a couple employees that have been there for years, saying, you're no longer to arrive till 9 o'clock, and your shift starts at 9 o'clock. You can no longer socialize. You cannot stay late just to hang out and chat. That changes a company's culture. It makes it cold. It doesn't want people to be loyal and stay there and grow in that company. I mean, will fundamentally change the way our employer-employer relationship is. And I would question for what reason. Why would we want to create that negativity in our Nevada family of employers and employees? Because the reality is, our biggest asset is our employees. That's why our employers constantly try to provide benefits, as Ms. Virginia was talking about. They have designed facilities to encourage that. The new chamber offices are designed the exact same way. We want our employees to interact, to be social. They go afterwards and hang out and do things. And they'll hang around like, hey, I got to wait for so-and-so because they're still wrapping up a project. We would have to tell them to leave the property right at 5 o'clock because they're just hanging out in the lobby waiting for that team member who may be salaried to finish up a project. So it does fundamentally change the way how we operate, and the financial exposure would be significant, and they don't have those resources. Thank you, Madam. Thank you, Chair. Thank you, member. Sorry. So sorry. Didn't mean to promote and demote. So sorry. Dang
It's all
employers.
good. Next question is from Assemblymember Ordlicker.
Thank you, Chair, and thank you for the presentation. So I appreciate the desire for clarity, and I'll expand that to predictability as well. And I know that we often incorporate federal law, but when it comes to predictability, by referring to federal law, that can be very unpredictable and change dramatically from administration to administration. So I'm concerned that if we, I appreciate your response, to the possibility that by changing it in the way you suggested, because there could be other ways, we just invite more unpredictability. And I'm sympathetic to the examples you've given. Yes, we want people to socialize, employers not have to pay for that. My concern is there may be hypotheticals on the other side, that some of the interpretations as federal court judges change and administrations change, that we might come up with some hypotheticals that would be less sympathetic. And so to avoid both problems, we could provide clarity in our law rather than, as I say, refer to a constantly changing body of law.
Paul Trimmer for the Nevada Resort Association. I understand exactly what you're saying. I think the best way to think of it is this. By incorporating federal law, federal regulations, we are essentially incorporating a gigantic library of regulatory guidance, court decisions. And you have to remember that when you're deciding whether work is compensable or not compensable, that decision is almost always best made case by case. So a judge or a labor commissioner can give you guidance and rulings on whether or not a particular type of activity is integral and indispensable to what the employee is doing, whether it starts the continuous workday, whether it's so burdensome and because it's required by the employer, it nonetheless requires compensation. Those are all factors under federal law as it sits right now. And there's an enormous body of case law and administrative rulemaking that allows businesses, especially large businesses, but even small businesses, the ability to research whether a particular practice is going to comply with or violate the law. And your point about changing decision makers and administrators is well taken. There have been some changes in federal law over the last 15 years about who might be exempt from overtime, for example. And Nevada law is pretty specific on who's exempt from overtime. But when it comes to compensable time and the types of, and the regulations we're dealing with here, and also when it comes to calculation of the regular rate, that body of law has remained consistent. Obviously, it's applied in different ways to different cases, but that body of law is relatively consistent, and you can determine what your obligations are. Though I'd have some concerns about being overly clear in a way with any type of statute when there's this enormous body of law already out there, and then we're once again arguing, well, what did the legislature mean when it enacted this particular provision or this particular rule? How did it intend to change or upset this well-established regulatory or this body of law? Because you have to remember the Portal to Portal Act was enacted in 1947, and many of the practices that hotel casinos in Las Vegas rely on have existed since the 60s, the 70s, and up until today with the modern casinos that began with the Mirage in the 1980s. And we've relied upon that, and there haven't been any questions about what things are required until recently. Like, everybody's always looking for a way to do something, I guess, is the best way to put it. And in this situation, employers are able to determine by looking at federal rules, federal cases, and and guidance from the Department of Labor to determine what our obligations are.
Assemblymember, you had mentioned some hypotheticals in the opposite direction. Did you want to provide us any examples of those hypotheticals?
Oh, yeah. So one that has been brought to my attention, and you may have heard that, so I appreciate the concern about you clock in and now you're socializing. But one of the interpretations I gathered of the PPA is that does it relate to your primary job responsibility? And so your employer asks you to do things that aren't part of your primary but still required by your employer, and that wouldn't be compensated, and another way of phrasing the requirement, instead of saying your primary responsibility, but is this required by your employer as part of your job responsibilities, which would make sure it's not too narrow a rule. So if you could respond to that.
Paul Trimmer for the Nevada Resort Association. Without identifying who I worked for, back in high school, I worked for a business in Las Vegas where I worked 7.5 hours a day, and then we were required to clock out, and then we spent 45 minutes afterwards cleaning up the park. That was off the clock work. It was compensable. There's no dispute that cleaning the facility for 45 minutes was part of my job duties because my employer required me to do it. There are situations where something that's post-preliminary or preliminary is not related to what you're doing. It's brief or de minimis, and examples where that wouldn't necessarily require compensation. And one of those issues involves, as I said, security screenings. It depends on the type of job. And I think we also have to be careful when you think about these hypotheticals not to let bad fact patterns create bad laws. Because a lot of this legislation is addressing, again, a broad hypothetical statement that the Nevada Supreme Court answered in the negative. It's not addressing the specific facts of the case against Amazon in the U.S. District Court of Nevada. And even in that case, the plaintiff and the defendant will still have to litigate, and a judge will still decide whether or not the time spent in those health screenings was compensable. This legislation wouldn't be dispositive of that. It would just be dispositive of what law actually applies. And so there's always going to be hypotheticals that you can create to show that a law is good or bad, depending on the circumstances. But what this legislation does is it allows us to utilize a huge body of law where courts and administrators having conducted research with 50 years of experience, have given us guidance on what is legal and what's not. And so I hope that answers your question.
Thank you so much. Our next question is from Assemblymember Considine.
Thank you, Chair. Thank you for bringing this bill. I'm sure that you can tell by how many people in the audience and up here that this has happened very fast, and there's a lot of people trying to navigate all of this. I think this case is less than a month old. I fully understand that the reason why we're here is because there's a special session, but if there wasn't a special session, there might have been more time to kind of digest and look. You know, we've talked about the long history that we have here, the creation that we've had. I know that this has been an understood idea since 1947, but Nevada being as different as we are and everything that we do, we've been able to sort of craft the laws for this to meet a lot of what we've created in this state. So I guess one of my questions, or the question that I get to ask now, is I understand why you're doing this now, because we have this special session, because this just came out. This is the best opportunity to do it. But I've heard from a lot of people that have some worries, that have some potential amendments, some things like an Ohio amendment, some things that would be able to be discussed or actually vetted out. And I don't know if that has happened or not. So I guess more of my question is, have you had those conversations with folks who, looking at our long history of the laws, bringing on the PPA overall, having any conversations about adding small amendments to this to keep sort of our Nevada way that we do things? Or is this sort of, we need this now and that's sort of it?
Paul Trimmer for the Resort Association. And I'm sure that Virginia and Paul can speak to this in more detail than I can, but I'll start if that's okay. And the goal of the legislation was not to change anything. It was to restore the status quo. Because everything that you're saying about particular tweaks under Nevada law, things that maybe the legislature wants to protect more than federal law does, those are things that require some deliberation. It's different than restoring the status quo as we understand it. And you have to remember how the Supreme Court approached this problem. It wasn't identifying how, it used the absence of law to come to the conclusion that that absence was meaningful and intentional and intended to change, for Nevada to be completely different than federal law and completely different than many other states. And that's why ensuring that the law references and incorporates federal law, which as a background principle is important because it preserves the status quo. And the provisions that are identified in the proposed legislation that illustrate what is compensable and not compensable, not only are they references to longstanding regulations, which haven't changed very much. They've been litigated by courts, but they also have been worked out with various stakeholders to make sure that those provisions are reflecting a status quo change, that this is not intended to benefit businesses in a way that the law doesn't benefit businesses now.
For Paul Morakin, for the record, and to follow up that Assemblymember Considine, so I think that's good. That's a good question. The reality is there were conversations from both sides about additional amendments. Even on our side, folks and members said, well, can we add this to do one more step to something else? Can we do this that'll be more beneficial to employers? And the Chamber's answer was no. Our premise and our request to the governor and to the legislative leadership is we want the status quo. We don't want to change anything and so forth, because that is not what our intention was or our request was. We just want to keep it exactly the same. And there have been conversations about modernizing the Labor Commissioner office. There has been conversations about clarifying additional definitions. And in all honesty, that is a conversation the Chamber is committed to in this room. And as you know, this organization I work for is honest. If we say we're going to commit to a conversation and see if there's a resolution for the 27th session, we will. And that's what our word has always been in this building. But to go any further or to reduce anything would not have been in line with the spirit of what we asked and with the proclamation. So that's why we've looked at those other amendments from both sides. There has been consultation with labor representatives. And the chamber has taken the time to try to share with them, consult with some folks. Is it all labor? No, in a special session, that's hard, as you can imagine. But the reality was that we did not anticipate this coming down. As you know, it came out October 30th. I believe we found out last Monday to put this request in because we're that concerned about the impact for all Nevada business. But I mean, just to that final answer, we are just trying to keep the status quo. We're not trying to change anything or do anything like that. I hope it helps. Thank you.
Virginia Valentine, I would just affirm the same things that my colleagues have said, and that is that we're just simply seeking the status quo. Unfortunately, I think it was merely 2 weeks ago barely 2 weeks ago that we found out about this decision. There isn't a whole lot of time to try to get very specific in statutes, and I've been up here for a while, and it seems like we try to avoid getting super prescriptive in statute when we do have a labor commissioner who can make decisions and we do have the opportunity to come back. But because this is so urgent and because of the exposure in the meantime, while this decision stands unchallenged, and while there's an open question about what applies, the exposure just was simply too great for us to wait. So we are very happy. I'll also confirm what my colleague Paul said. Very happy to work with you on the interim. We may know a lot more in 2027 and may be able to make additional changes that further clarify.
Thank you. Our next question is from Assemblymember Roth.
Thank you, Chair, and thank you so much for the presentation. Kind of going off of what the status quo is, I think that's where my concern lies, of just understanding what is the status quo. To be completely honest, I'm hearing it from both sides, that on one end, the status quo has been that Nevada protections are broader and been understood to be broader than the Portal to Portal Act. And then what I'm hearing now is that the understanding for employees and employers are that the Portal to Portal Act or federal regulations have always kind of controlled. And so, like any good lawyer who practices in a different field of law, first thing I did was Google this, right? And, what came up, and this is from Jackson and Lewis Law Firm, and the first line is that the laws of Nevada and Arizona require employers to pay their workers for time spent through security screenings, and that's from the Busk decision in 2018. And so can you just clarify so that we can have a better, or I can have a better understanding, what is the status quo? Because my concern lies with employees who already have claims pending that are based on the fact that they understood Nevada law to have broader protections than the federal law.
Paul Trimmer for the Resort Association. So I think it's important to think about where, if we're sort of focusing in on this, the security screenings for Amazon as the starting point, it's important to remember that that case originally started in 2011 or 12. The first version of whether or not those types of screenings were compensable. And the lawsuit was brought in Nevada and other places. And I think it's really important to take into account that when that lawsuit was first being litigated, it concerned federal law. There was no claim, oh, well, Nevada law is more favorable, it's different. That wasn't the argument by those lawyers. It started out with Integrity Staffing versus Busk, the case that went to the U.S. Supreme Court. And the argument was that the security screenings were compensable under the Portal to Portal Act. Ultimately, the U.S. Supreme Court ruled that they weren't. After that lawsuit went away, the same lawyers filed lawsuits claiming that they had now concluded and discovered that Nevada's laws were more protective than federal law, even though they hadn't alleged that in the first case. And that case went to a multi-district, into what's called a multi-district litigation court, where many different lawsuits in several different states were consolidated for purposes of pretrial proceedings. And ultimately, as referenced in that internet article, the Sixth Circuit Court of Appeals concluded that if it was forced to guess what Nevada law, the Nevada Supreme Court would do, it believed the Nevada Supreme Court would conclude that the screenings at Amazon were compensable. But the Sixth Circuit predicting what the Nevada Supreme Court might do is not the same thing as the Nevada Supreme Court actually making a decision. And I referenced this during my initial presentation, but I think it's important to note that the lawyers litigating that case have litigated several cases before the Nevada Supreme Court. And while they may be saying now that employers were on notice in 2018 that there had been this change in the law, when this case has been litigated these types of issues have been litigated in the Supreme Court before, those lawyers have argued that federal decisions are not binding. They did it when it came to overtime and the private right of action. They did it when it came to the statute of limitations. So this decision that they are holding up as a bellwether for what the law really is the same kind of decision that they have denigrated and argued does not control what the Nevada Supreme Court says. And as a practitioner in Nevada, it never would have occurred to me that when answering this, it's possible that a security check like that in the Amazon case could have been deemed compensable. That like the district court in Nevada could still, the U.S. district court that's hearing that case right now, still could come to that conclusion. But in answering the very, very broad question of whether or not Nevada law incorporates federal law, and you can see this in the Malloy decision itself, when the Nevada Supreme Court has not issued that many decisions dealing with wage and hour law, but in general, it has said that we follow federal law unless the Nevada legislature says otherwise. It has never reached the conclusion that by failing to speak, you spoke otherwise. And that was the interpretation and analysis that was used in this case. And so I understand the concern that this would be changing someone's rights, but I also think it's important to consider the reliance interest that employers, especially large employers, have had on the belief that federal law sets the background principles for Nevada wage and hour law. Because if we disregard those background principles, we're immediately looking at 3 years of liability for thousands or hundreds of thousands of hours of work. The amount of liability based on the legislature's failure to speak is existential for some businesses. And that's why we're seeking to restore the status quo. So it doesn't end litigation. It just means that we're litigating over the same disputes that we thought we've had all along. For example, if we were asking you to change the tip credit law, that would be, well, A, it's a non-starter, that's not what we're trying to do. B, it would be a significant departure, and employees would definitely have thought that they were protected when it came to tip credits, or to tips. And I would agree with your argument completely in that situation. But what we're dealing with right now, we're dealing with this background principle of whether or not federal law gives us guidance or not. And so I don't think that this does anything to change or diminish employee rights. It ensures that everyone's on the same playing field, and then we allow judges and the labor commissioner to make decisions on a case-by-case basis the way they always have.
Okay, thank you. We're going to take our next question from Assemblymember Karas.
Thank you, Chair. I think we can all agree that this is a very complex issue that needs much, much more deep thought and consideration in all aspects for workers and for employers. My concern, and I'm just going to say it, I'd like to see this play out for a couple months because we will be coming back for session. I'd like to have a long and deep conversation during next session, and maybe we will find ways, if things get screwed up, that we can fix them, and if things are going smoothly, that we can tighten it. I would like, my question actually is, I would like right now to ask for a commitment, solid commitment in good faith from the presenters to work in good faith on this bill should it move forward.
Assemblymember Karas, so just to clarify, I'm just clarifying, so if the bill moves forward, we would then work an interim period on another follow-up bill? I just want to clarify your request. Sorry.
I'm sorry, what I'm going for is we watch, and if this moves forward, that we watch and see what happens, and that all of you would be willing, as good stakeholders and all members that are concerned about this, all stakeholders, all get together and really sit down and make this a viable and workable thing for all the people of Nevada.
And Paul Morakin for the record. So thank you. Absolutely. And I did make in my comments that the chamber would absolutely engage in the interim period to further address any concerns, moralizations, whatever we may need to do. And again, we are committed to that conversation on behalf of the Vegas Chamber, and we will be part of those conversations.
Virginia Valentine, and we would welcome the opportunity to participate with other stakeholders to have that conversation as we see how this plays out, as you said. Thank you.
Thank you for putting that on the record. Thank you, Chair.
Thank you so much. We have a question from Assemblymember Gurr.
Thank you, Chair. I'm not sure how much of a question it is. It might be more of a statement, but in the eastern half of the state of Nevada, safety is a major issue for the employers there. Have you addressed the safety side of this thing?
Paul Trimmer for the Nevada Resort Association. So when I think of safety in terms of compensable time, the thing that comes to mind first is wearing protective gear. And there is a huge body of law under the Portal to Portal Act addressing the circumstances under which donning and doffing protective gear is compensable. And the case that is the most famous case that employers rely upon for determining what their obligations might be is called IBP versus Alvarez. It involves butchers that had to wear a significant amount of protective gear in a high-speed, high-volume butchering facility. And in that case, courts concluded that because the employees could not take that gear at home, that because the gear was absolutely integral and indispensable to performing their job because they had to protect themselves from knife wounds, and because it took a significant amount of time to put that gear on, it was compensable. They couldn't do their job without it, and it wasn't something they could bring home or anything like a typical T-shirt or polo shirt and pants, a uniform you wear in some other job. And so, again, this is an example of how looking to existing rulemaking, existing decisions is the best way for employers to have guidance about how to proceed. Because in the absence of relying on federal law, we're in a world where this Supreme Court decision still controls. We have no guidance whatsoever. We're guessing about what other states that are not Nevada have done, and we'll be asking our judges not to listen to what you have said, but to listen to what other courts in other states have said, because those are the precedents that they should rely upon. And that doesn't make a lot of sense to me. What seems like the best approach is relying on this stable body of federal law, and then, to your point, looking at the status quo and then making deliberate change if that's necessary through either administrative rulemaking by the Labor Commissioner or by decisions of this body as we move forward. But failing to take action now exposes employers to 3 years of existential liability.
That brings up, excuse me, that brings up more of my statement part of it, I suppose. Safety, that way, I certainly appreciate that and get that. When we have 4,000 to 6,000 employees living in the general area where I do, that have to travel anywhere from an hour to an hour and a half to get to work, the employers right now are taking care of all that. There's no demands on them when they come there. There's nothing there. So what would happen if this comes in my mind, nobody said this is the way I envision it happening if we don't pass this bill, is that we would be putting those folks on the road for 3 hours a day plus their 12-hour shift, and that becomes a huge public safety risk to me. So I think we got to look at that really closely as we go through. And I know that the industries will probably speak to that, but I wanted to make it on the record that it's a super important issue here in my part of the state.
Thank you, Assemblymember. Our next question is from Assemblymember Roth.
Thank you, Chair. My second question is in regards to the overtime and the worked hours definition. So if you could just explain how the language in this bill will change the computing of overtime as it currently stands in Nevada law.
Paul Trimmer for the Resort Association. This wouldn't, as we understand it, would not change anything, because Nevada law doesn't specifically provide for a method to calculate overtime compensation. And because Nevada law has never spoken differently, employers in Nevada have believed that we use the regular rate calculation that's in the FLSA. That's what everyone does, because you have to comply with that as a matter of federal law. There's no reason for Nevada to have a different approach to overtime overtime compensation calculation than every other state. And I'm not aware of any state, there might be one, I don't practice everywhere obviously, but I'm not aware of any state that uses a calculation methodology that differs from the FLSA. So, but this is intended to, I think the need for that amendment almost illustrates the profound uncertainty that employers will be confronting if the absence of Nevada guidance means that there is no law on that issue, and that this legislature intended for employers to do something differently. We're incorporating this because regular rate cases can be a huge problem if employers miscalculate the regular rate. So we want to make sure that the absence of a regular rate calculation methodology doesn't mean that anyone is doing it wrong. Because when it comes to overtime and making mistakes, your liability can add up very quickly. And if there was an argument that Nevada law required something different, even if the employers disagreed, this is an example of a situation where everyone believes that federal law prevails, but the interpretive methodology utilized in Malloy could suggest otherwise.
Thank you for your indulgence, Chair. And so this is like a crash course for me. I appreciate it. So that wouldn't, I guess, does like hazard pay and things like that, would that change under the language of this?
No. So, sorry, Paul Trimmer for the Resort Association. No, the regular rate methodology includes any sort of, I'm going to call them spiffs, but any wage enhancements that employees earn during the course of their work week, it includes that. It also includes non-discretionary bonuses. So you use that to determine what the employee's actual compensation rate is per hour, and then you multiply it by 1.5 times to come up with what their overtime rate is. The issue is that there has been some litigation that we've heard about where plaintiffs' lawyers are arguing to use a different approach, which would be what you just described, including hazard pay, which is not controversial in any way, but also to include the value of employer-sponsored benefit plans. So in addition to overtime, or in addition to all the things that you're describing, you would also include the value of employer 401k contributions. You would also include the value of the employer's contribution to health insurance for calculating overtime. And there's not a single state in the country that does that. But that's an argument that they're making, and it becomes dangerous because of the Malloy decision, which says in the absence of Nevada law, we're going to assume something else. And that's why we've included it there.
Thank you so much. Our next question comes from Assemblymember Considine.
Thank you, Chair. I appreciate the second question in indulgence. So I'm just trying to digest all of this. And our gaming, our resorts, we're all over the country now. Gaming is everywhere. So what I don't know is Nevada the only state that isn't under this portal-to-portal bill? If there are other states that don't have this as in their law, do we have any of the resorts that are here in those states? And if so, how is that treated differently? That was one really long question. Thank you.
Paul Trimmer for the Resort Association. There are other states that have rejected application of the Portal-to-Portal Act in which casinos operate. But I'm a Nevada lawyer, so I'm not knowledgeable enough about the practices in those states to figure out if anything has changed. All of those well, not every state, but other than Atlantic City, as you know, most states that allow for full gaming, that's a relatively recent phenomenon. Nevada has had full-service resorts, unrestricted gaming licenses for a very long time. New Jersey in Atlantic City also has. But as gaming companies have moved into other jurisdictions, they're adapting to and complying with the laws in those jurisdictions. But how they're doing that, I'm not an expert on that.
Thank you. So I don't know if you can answer this question or not, if anyone else can. In those states, do the benefits that, like we were talking about earlier, if somebody coming in early, the dry cleaning, any of that, is that still available in those states? And maybe that's a question you can't answer today. Or is that not available because they're not under the Portal Act?
Virginia Valentine, let me see if we can get an answer to that question. So I don't have the answer for you right at this moment. Thank you.
Indeed. Do you need to bring someone else up? Or are you phoning a friend?
Virginia Valentine, I'd like to have someone ask the question of someone who may have the answer. So I'm asking for a lifeline here. So.
Okay, so a lifeline. That lifeline's not in the room where we can
Not
just
in
bring
the room. Thank
okay. We will give you a few moments for that then. So we will just be at ease for a few moments.
We may have, Virginia Valentine, for the record, we may have to get back to you after the meeting. We don't have anyone in the room who can answer that question. Thank you.
Okay, thank you so much for that. We certainly understand. But for the sake of time, we'll move forward. And if you get that answer while we're in committee, we would appreciate that response while we're still in committee. Right now, it doesn't look like we have any additional questions. So we will move forward with testimony. And so as I stated before, we will have 1 hour of testimony in support, 1 hour of testimony in opposition, and 1 hour of testimony, if needed, in neutral. I'm going to start in Las Vegas just because there's fewer people there, and that way you don't have to wait as long. Is there anyone in Las Vegas that would like to testify in support of Senate Bill 8? Again, for everyone testifying, I ask that you state your name, spell it so we have it accurate for the record, and please keep your comments to 2 minutes each. So there in Las Vegas, please proceed when you're ready.
Thank you, Chair and members of the committee. My name is Emily Osterberg, Osterberg, representing the Henderson Chamber of Commerce and our over 2,200 members, the majority of whom are small businesses, here in support of SB 8. The Amazon v. Malloy ruling represents a significant departure from what employers reasonably understood the law to be. Its consequences are far-reaching and potentially devastating for Nevada businesses, including small businesses. Because of this, we support the current version of the bill that includes retroactive dates to this coverage. Thank you for your time and consideration.
Thank you so much. And not seeing anyone else in Las Vegas approach, we'll come back up here to Carson City. Just a reminder too, we always remind folks when we have a lot of testimony that if you're stating the same exact thing that someone before you did, you are more than invited to say ditto or this reflects the same statements, just because that gives the opportunity for more individuals and more affiliations to be recognized as well. So with that, please proceed.
Good afternoon, Chair and members of the committee. For the record, my name is Annette Magnus, and I'm here today representing the Retail Association of Nevada. Many of you have known me for many years. I come from a long line of union leaders. My uncle was the Secretary-Treasurer of the Culinary Union. My grandfather was the Secretary-Treasurer of the Building Trades Union, all in Las Vegas. I think you know where I stand on these issues. I would not be advocating for something that I did not feel was sound for Nevada's workers and employers.
This bill is an opportunity to set a level playing field after a court decision that has caused confusion in our workplaces. We need to ensure that Nevadans, both employers and employees, understand the rules, and we can make sure that employees are paid for the time that they are required to work. I believe that this is an excellent start to that conversation, and that RAN is committed to participating in a robust conversation during the interim and next session. Businesses, especially our small businesses, set their prices to be able to pay all their expenses and make decisions based on stable, long-standing labor law. To have decades of law overturned and applied retroactively robs businesses of the ability to set prices to cover all of the possible expenses. Nevada businesses have had no way to prepare for these expenses. We can't go back and adjust our business models to compensate. If you vote no on SB 8, prices may have to be raised to allow a business to handle this new liability. This bill is just the start to get clarity between the federal law and the state law. That's all. I would not be here advocating for something I didn't believe would harm workers, or that I believe would harm workers. I encourage your support.
Thank you so much, and will you please spell your name for the record?
ANNETTEMAGNUS.
Thank you so much.
Thank you, Madam Chair and members of the committee. My name is Nikki Bailey Lundahl, NIKKI-BAILEY-LUNDAHL. And I am here on behalf of the Nevada Mining Association and our hundreds of member companies across this state. We are here in support of Senate Bill 8. We appreciate the hard work that has gone into crafting this measure and helps to solve an acute and specific challenge that has arisen for our industry. For many years, I've had the privilege of showing off Nevada's world-class mining industry to you all. You have seen our remote operations. You understand the long distances between our sites and the nearest town. You have seen firsthand the great lengths miners go to protect their employees and to protect one another. For example, some miners require employees to ride a company shuttle from town to mine site. On this shuttle, employees can sleep, rest, call their families, even scroll social media. We do not ask them to do anything on these shuttles. Under current law and spelled out in NAC 608.130, this is clearly not compensable time. But coming out of the Malloy decision, it is not clear whether our work to keep our employees safe or even that regulation will withstand judicial review if challenged. And I'm here before you to appeal for that clarity. I do not claim to be a labor lawyer, but I can tell you definitively that since Malloy, a single Texas-based law firm has targeted our industry with more than 10 class action lawsuits. These lawsuits target the industry over things that do not qualify as compensable work under current law, whether traveling to a site or to gearing up to go underground. These suits have one thing in common: they rely on the uncertainty coming out of the Malloy decision to disrupt our industry. I want to repeat, we have members being sued for something that is clearly legal under current law, based not on specific violations, but on the uncertainty this ruling has generated. We believe the current labor law should be enough to protect our operations and our personnel. But post-Malloy, following the law as written and the regs that enforce those laws, that protection no longer seems like a guarantee. We are not looking for any special treatment or to gain any new ground.
Thank you, but your time is up.
Thank you.
Thank you.
Good afternoon, Chair and committee members. For the record, Becky Dutro, D-U-T-R-O, with Nevada Taxpayers Association. The association is in support of this bill and the importance of simply codifying what taxpayers in Nevada have always understood the law to be, and does not remove any employee protections. This is good public policy for all Nevadans, businesses, employers, and taxpayers, to assist with the uncertainty that this court case has caused. Thank you for your time and consideration of this bill.
Thank you, Maggie O'Flaherty, for the record, MAGGIE-O''FLAHERTY, here representing the Builders Association of Northern Nevada. Here to testify in support of SB 8. I echo the comments made already about the detail that my colleagues went into detail and the worries and waiting to make this fix now. We are seeking to clarify this standard under which these lawsuits are brought. not go back and automatically or otherwise invalidate pending litigation, but simply clarify the law and the standard. And to the point of what was, in fact, the status quo over the last several years, there would be no reason to certify a question to the Nevada Supreme Court if we had a pre-existing understanding of that status quo dating back to 2018. The questions around whether Nevada employment attorneys were surprised by this holding is extremely pertinent because context matters in this situation, and how industry practice has evolved over decades matters. So when a gray area exists in law, it makes both employers and employees extremely vulnerable. BAN represents small family-owned builders that can't afford that type of uncertainty. We are asking to clarify this issue within the context of our extremely shortened time in Carson City, with the understanding that we will come to the table in the interim and discuss this more. But this fix that we're proposing today is the simplest and most effective fix that we can achieve until 2027. And it's the exact codification that we've been functionally operating under in a good faith belief on both sides since the federal government adopted the PPA. Assemblymember Constein, you are right that Nevada likes to do its own things in its own way. And we have set a floor based on a 70-year precedence that we are seeking to codify. It by no means sets the ceiling for more to be done. And again, we are very willing to come to the table in the interim and committed to doing that. Thank you.
Good afternoon, Chair, members of the committee. Carrie Kramer, Kerriekramer, here on behalf of NAIOP Nevada, Nevada's commercial real estate organization representing all facets of commercial development, big and small. We are here in support of SB 8. This bill does not change anything. It simply gives clarity to the law, and we stand ready to have a substantive discussion during the 2027 session as well as the interim, if necessary. Thank you so much.
Good afternoon, Speaker Yeager, Chair Miller, and members of the committee. I'm Amy Sjogren, that's S-H-O-G-R-E-N, with Black & Wadhams on behalf of the Nevada Hospital Association today. I would like to echo the sentiments of my colleagues in support of SB 8. Thank you very much.
Thank you. My name is Alexis Motorex, Alexis Motarex, with the Nevada Chapter Associated General Contractors, here in strong support of SB 8. As it has already been stated, but I don't think it can be stated strongly enough, this does not take away any employee's existing rights, and it does not impact existing CBAs. It simply provides stability to employers to continue doing business as they have done for decades, under the assumption that the Portal to Portal Act exemptions apply in Nevada. And I, too, will commit that AGC will work with all stakeholders throughout the interim and next session to modernize and make changes if necessary to NRS 608. Thank you.
Good afternoon, Harrison Bohn, Harrisonbohn, from Brownstein, on behalf of Peter Guzman and the Latin Chamber of Commerce, here in support of SB 8. The Latin Chamber represents hundreds of small businesses throughout Nevada, and they require predictability in law so they can focus on their day-to-day operations. I'll call out Assemblymember Hardy for her great question earlier. Thank you for keying in on that. SB 8 is essential to maintain the legal understanding and stability. Starting and running a small business takes a tremendous amount of effort and risk, and it's also at the heart of the American dream. But the fear of a lawsuit can and will put their livelihood at risk. The Latin Chamber encourages this body to support SB 8 and continue to support small businesses like they've done countless times before. Thank you.
Good afternoon, committee members. Russell Rowe here on behalf of ACEC of Nevada. That's the trade association representing engineers and design professionals in Nevada, with approximately 2,000 employees in the state. ACEC supports the adoption of SB 8 to maintain stability and predictability of the rules governing the employer-employee relationship. Most engineering firms in Nevada are small businesses. While engineers and their professional staff are brilliant at designing bridges and buildings that remain safe and sound, their small firms lack the human resources to understand and implement a significant and sudden departure from the standard custom and practice of Nevada employment law. ACEC supports the adoption of SB 8, and we likewise support the continued discussion of these important issues among all stakeholders to address any issues and concerns that should be addressed in a more global, comprehensive manner during a regular session of the legislature. Nevada's engineering community thanks this body for your consideration of this important legislation.
Could you spell your name for the record, please?
ROWE. Thank you, Madam Chair.
Good afternoon, Madam Chair, members of the committee. For the record, I'm Paul Enos, P-A-U-L-E-N-O-S. I am the CEO of the Nevada Trucking Association, and we're here today to support Senate Bill 8. Yeah, a truck driver's day is regulated by federal law. You know, how much time you can drive, how much time you have to be on duty, when you're off duty, when you're loading or unloading. And one of the pieces of flexibility that truck drivers have been given is being able to use that truck for personal conveyance. That's a great thing for a driver. That means, hey, maybe I don't want to eat at the truck stop. Maybe I want to go down the street to a nice restaurant. Maybe I can run an errand, go to the dentist, go to the doctor when I'm on the road. We are fearful that if the law stands currently, as the Supreme Court has determined it, that companies, with the threat of now that time when you're in personal conveyance, that may become compensable, that our drivers are no longer going to have that flexibility. So we believe that the legislature has an opportunity in this special session to legislate a fix as opposed to litigating it. Because if we litigate it, we don't know what the rules are until that case plays out. So I just ask this body, you know, for my industry to maintain that flexibility for our truck drivers so they can park in a safe place, so they can go to the dentist, so they can use that truck for personal conveyance when they're on the road, and give us some certainty, because we are afraid that, hey, we could go back 3 years, and every time a driver used personal conveyance, that may now be compensable, and that subjects those companies to a lawsuit. So we appreciate your consideration and ask you to adopt Senate Bill 8. Thank you.
Good afternoon, Chair and Committee. Shelley Capurro, SHELLYCAPURRO, representing the Reno Sparks Chamber of Commerce, and Ken Ross-Gold. We are in strong support of SB 8, and we want to thank all of the business community and everyone involved in this for working on this very important issue. Thank you.
Good afternoon, Madam Chair, members of the committee. For the record, Andrew McKay, ANDREWMACKAY. I'm the Executive Director of the Nevada Franchise Auto Dealers Association. Brevity of time, obviously echo all of my colleagues' comments with respect to this. This is the emphasis. This is to maintain the status quo, and I think Mr. Rowe nailed it. And he had two words that I just want to emphasize. This maintains stability and predictability, which all businesses, large and small, rely on when they obviously plan short-term and long-term. So respectfully, we request the committee's support of this. And again, Madam Chair, I'd be remiss if I did not say that in the interim, if working groups or any other type of organizations, or maybe that's a bad word, where all of the various entities are going to sit around the table, we commit to being involved in that. I think our record is very clear that we have done that whenever there's something that either is unresolved at the legislature, but more importantly, something that is resolved and we want to continue to work on it. So you have that commitment. Thank you, ma'am.
Thank you, Chair and members of the committee. My name is Jay Parmer, Jayparmer. I'm here on behalf of the Nevada Manufacturers Association, urging your support for Senate Bill number 8. There are over 2,000 manufacturers in the state of Nevada that have found themselves impacted by the ruling and the uncertainty that comes with the ruling from the Supreme Court. We would urge your passage of Senate Bill 8 as an opportunity to restore a more level playing field, restore some clarity to the situation and the longstanding practices, labor practices of our industry. And we would look forward to participating in further discussions on this issue going into the 2027 session. But for now, we would urge your support for the passage of Senate Bill 8. Thank you.
Chair and members of the committee, thank you for hearing the bill. I'm Eric Hansen, the Chief Sustainability and Government Affairs Officer for Wynn Resorts. The Wynn supports SB 8 because it ensures consistency with longstanding and current practices by bringing Nevada's labor and wage laws in line with federal standards. Nevada employers have long relied on the good faith understanding that the Portal to Portal Act was incorporated in Nevada until this very recent Nevada Supreme Court decision. Wynn Resorts prides itself on how well we take care of our 13,000 employees. We need them and they need us. Bringing back that stability that was upset by this ruling is crucial. We thank this body for restoring the status quo and ensuring predictability for the many key industries, large and small, across our state. We urge your support on SB 8.
Thank you. Could you spell your name, please?
Yes. Sorry, Eric Hansen, ERIKHANSEN.
Good afternoon, Madam Chair, members of the committee. For the record, Erin Midby, Vice President of Government Affairs for Boyd Gaming. We also are in strong support of this legislation, as we believe, as you've heard many times, that it does maintain the status quo and brings clarity and predictability to both employers and employees, which is critically important. So we would urge your support, and thank you so much for taking the time to hear this.
Thank you. And can you spell your name as well? I know it's
Yes,
so
thank
awkward.
you so
We don't do
much.
this in real life, but
Erin Midby, ERINMID, as in David, B as in boy, Y. Thank you.
Thank you.
Good afternoon, Chelsea Capurro, CHELSEA CAPURRO, here on behalf of the Nevada Subcontractors Association, local Nevada businesses, big and small throughout this state, construction industry. I'm not going to belabor the point and continue to go on what my colleagues have said, but we urge your support on this bill. Thank you.
Good afternoon, Madam Chair. For the record, Mindy Elliott, MENDYELLIOTT, with Flynn Judici Government Affairs, here today representing American AVK, which is a company, manufacturing company just up the road that is in the process of bringing not one, but 2 additional lines of business from China. They're going to be just opening very soon, bringing over 300 new employees, new jobs. I appreciate my previous comments from all of my colleagues, and we appreciate your hearing this bill today, and we support the bill as amended. Thank you.
Good afternoon, Madam Chair. For the record, Jason Gray, GRAY, Vice President, Government Affairs for MGM Resorts International, here to testify in strong support of Senate Bill 8. As Nevada's largest private sector taxpayer and employer, with approximately 40,000 team members in Southern Nevada, MGM Resorts supports accelerated action to address a sudden and expansive Nevada Supreme Court opinion in Malloy that unfortunately put all Nevada employers in a very precarious situation. Senate Bill 8 is intended to reestablish the status quo prior to Malloy, and in so doing, fairly and properly protect employers and job creators from material, substantial monetary exposure and anticipated harmful operational impacts. I urge your support. Thank you.
Good afternoon, Madam Chair. Carlos Lasane, KARLOS, capital SANE. On behalf of Caesars Entertainment, we are in full support of SB 8. And I'd like to join my colleagues. The strength of our industry, how united we are, how we take care of our employees, I would hate for that to go away. If we don't pass this bill, it would be seismic changes to our industry. I can't convey that to you enough. We care deeply about our workforce. Please support SB 8. Thank you very much.
Thank you. Is there anyone else here in Carson City wishing to offer support on Senate Bill 8? Okay, not seeing anyone, then we will close support testimony for SB 8 and open opposition testimony. I will begin in Las Vegas. Las Vegas, is there anyone that would like to oppose? Please come forward, and again, please state your name, your affiliation if you have one. Spell your name, and you will have 2 minutes each. What time is it? Las Vegas, please begin when you're ready.
Hello, my name is Paula Luna, PAULA-LUNA, on behalf of Battleborn Progress. This bill weakens the Nevada wage protections to benefit mega corporations at the expense of working families. This bill tries to turn mandatory work tasks like briefing your manager, inventory costs, vehicle maintenance, mandatory training, etc., into unpaid tasks to be done off the clock. This is a solution in search of a problem where one does not exist. Excuse me. This is not an emergency, and hearing this bill is a waste of taxpayer dollars. Time worked should be time paid. We stand opposed to this bill and ask this body to reject SB 8. Thank you.
Good afternoon, Chair Miller and members of the committee. My name is Jackie Spicer, JACKIE-SPICER, representing the Nevada Environmental Justice Coalition. Our coalition has advocated for worker protections over the past 2 legislative sessions, and today speak in solidarity with the Nevada AFL-CIO, the actual voice for working people in our state, to respectfully ask that you vote no on SB 8. I'm also sharing testimony for folks who could not be present today, both the Native Voters Alliance of Nevada and the Great Basin Resource Watch. On behalf of my colleague, Matilda Miller with the Native Voters Alliance of Nevada, we stand in firm opposition. Ms. Miller finds it deeply alarming that this body is considering language that would weaken wages and working conditions in sectors like mining, where so many Indigenous people work to support their families. It is equally alarming that telephonic testimony is still blocked, forcing sovereign tribal nations like Duckwater and Goshu to travel more than 12 hours round trip for the basic right to be heard. Thank you for your time and dedication to the people of our state.
I'll go first.
No, you won't. We're still in Las Vegas. Las Vegas, are you testifying in opposition?
Yes, we are testifying in opposition. My name is Leon Greenberg, Leon Greenberg. Good afternoon. I'm an attorney here in Las Vegas who exclusively represents workers primarily involving wage disputes. I've represented many workers involving minimum wage claims, mostly workers who aren't represented by unions and don't have anyone to speak out for them, unlike many of the industry representatives you've heard from today. You've heard a lot about how this bill will restore the status quo. There is no restoration of a status quo in this bill. This bill is designed to remove from Nevada law a very fundamental principle that I think everyone on this committee would agree, which is that if your employer tells you to do something and requires it of you and it takes a certain amount of time, you should be paid for that time. And that is fundamentally what is at issue when Amazon requires workers to clock out and then wait to go through a security screening. Wait until Amazon decides they've had enough people to do the security screening, and let people just wait until Amazon decides that they can go through security and then not pay them. This bill is a great affront to a very basic protection of workers. I also want to point out that the fiscal note is inaccurate on this bill because it will have a fiscal impact. If employers do not have to pay wages, they don't have to pay Nevada's general business tax, which is assessed against employers' wages. So there will be a fiscal impact to the state by allowing employers to not pay wages for time that they otherwise do have to pay for. And again, this bill is not seeking to restore any status quo. It is seeking to exempt employers from paying for certain time that they have always paid for. Thank you for taking the time to hear from me.
Thank you so much. And at this point, is there anyone else in Las Vegas that would like to testify in opposition? Not seeing anyone, then we will move up here to Carson City. Please proceed.
Thank you, Madam Chair. Skip Daly for the record on behalf of myself. I'm here in opposition to Senate Bill 8. I was in opposition in the committee on the floor and continue to be so. What you have in front of you is an issue to address a problem. I'll do what I can in 2 minutes. Can't get to everything, but the bottom line is that workers in Nevada will have less protections than they have now. They will have less ability to get paid for the time that they're required to be there by the employer. And if you look at the language of the Portal to Portal Act, it says it opens a lane at the beginning of shift and at the end of shift. And the solution here is everything for one side of the equation, nothing for the workers' side. We asked on the other side. I spent 2 hours working with them trying to talk about putting in a definition of what work means. That definition, as Mr. Trimmer said, that absence of definition is going to mean something in the Nevada. So when they start trying to say, hey, preliminary and post-preliminary work is covered by the Portal Act, and I don't have to pay you, if we haven't defined work, it's opening the door way too wide, and it's going to be detrimental to the workers. And you heard them all come up and say, and I've dealt with this in the legislative life, that says, oh, we'll engage, we'll come and talk with you. They'll come sit in your office, they'll come look at you and say, oh, yeah, thanks for your input. And then they'll walk away and not agree to anything, as they did when I tried to talk to them to put a potential amendment on there. I think we still have opportunity for that. And when I look at how come they think they can do that, how come they get away with it all the time, and the answer is habit. Let's try to break the habit. I think you have an opportunity to stand up for Nevada workers, give them that definition of wages or work, definition of work, make that statement, so then we can go forward with all the rest of the case law and various thing and what is
Thank you,
primary
Senator,
activity.
but your time is up.
Is all done.
And also,
Thank you.
will you spell your name for the record, please? Just,
D-A-L-Y is my last name.
thank you so much. Next, please.
Misha Ray here on behalf of the Nevada Justice Association, MISHARAY. We've heard from a lot of employers today, a lot of employers saying that we're just going back to the status quo, and for that, we have a fundamental disagreement. Thankfully, we don't have to rely on a hypothetical of what would be or would not be compensable time. We have litigated case law that would say what Nevada, what is before you, what is being asked of you to enact. The U.S. Supreme Court told warehouse workers at Amazon that they could not be compensated under this bill that is before you, this Portal to Portal Act, for the 20 to 30 minutes after their shift that it took them to go through an airport-like anti-theft security screening. It took 20 to 30 minutes for which they could not be compensated under the Portal to Portal Act. That was the federal law. That is what you're being asked to enact now. In 2018, the Sixth Circuit Court of Appeals ruled that under Nevada law, as it is right now, that time is compensable. We heard from the employer side that at that time, the Sixth Circuit Court of Appeals had to guess what the Nevada Supreme Court would say. They had no idea what the Nevada Supreme Court would say. We know now the Nevada Supreme Court agreed with that court. We know now that the Nevada Supreme Court agrees that any hour you work that is required by your employer should be compensated. We know, we've heard a lot of hypotheticals that the wellness activities have to be closed. Those are optional, provided by the employers, that are benefits. You are not required to get to your shift early and use the gym, eat a meal in the cafeteria, drop your child off at daycare. Those are not required activities, but activities that are required by your employer should be compensated. It is not reasonably shocking that the Nevada Supreme Court agreed with the Sixth Circuit Court of Appeals. That is our opinion. This status quo argument is, from the employee perspective, not persuasive. We have, as Nevada Justice Association, offered a couple of options for amendment that have been presented to you. We would request your consideration on those amendments. Thank you.
Good afternoon. My name is Leah, L-E-A-H Jones, J-O-N-E-S. I am an attorney partner at Thurman Buck Law Firm. I have a unique perspective on what is going on here today because Thurman Buck litigated both the integrity and the Busk cases in the Ninth Circuit to the Supreme Court, to the Sixth Circuit, back to state court, and we also argued in front of the Nevada Supreme Court on the Malloy case. I am happy to clarify some inaccurate statements made by the other side on those cases and what they actually held. I am here to share with you some real-world instances where employees who do not have anyone else fighting for them besides me, the attorneys at Thurman Buck, and maybe 6 other attorneys in the state of Nevada. I would like to rebut some of the accusations and the issues that the people that brought forth this bill and give my point of view from a plaintiff side to your hypotheticals from Assemblymember Roth, from Assemblymember Yeager, and anybody else. I will yield to Madam Chairwoman at this time, but I hope that you will let me expand on some of those issues throughout the testimony. Thank you.
We welcome you to submit them in writing, and then we can disperse it throughout the entire committee. Thank you so much.
Greg Esposito, representing the Plumbers and Pipefitters Local 525. I'm not in the habit of jumping in front of freight trains, but your rules dictate that if I'd like to see a single change, then I have to stand in opposition of the bill. I hope that my reputation in the building is that I'm probably one of the most business understanding union representatives you're going to find. I get that business and workers are 50% of each equation, and without each other, neither of us survive. So I'm in full support of the proponents of the bill having a set of rules that they can follow, that they can understand, that the workers can get paid by, that they could do business by, because they stay in business, we stay in business. However, there are a few things that are in the federal regulations that are not currently in Nevada regulations that, to previous points made, this isn't quite the status quo. Federal regulations say that a principal activity is defined as integral and indispensable to the job. Under that definition, things like security checks, waiting in line at checkpoints, filling out non-essential paperwork, and certain unpaid meetings are not compensable, whereas currently they are compensable under Nevada law. As far as, a generic company values and safety culture talk can go unpaid under federal regulation, whereas currently in Nevada, if you're there and they're having you be there, you're paid. So that's the concept of what our opposition is. Federal law, you can be on the job doing what the employer tells you and not get paid. That's not how we operate. And that's not how any of the proponents that came to the table operate. I know this. But if you change it to simply mimic the federal regulations, that's a possibility. And unscrupulous businesses will take advantage of that possibility, I guarantee you. The fix is very simple. Well, to my concern, the very simple sentence, accept those at the direction and control of the employer. Tasks at the direction and control of the employer should be paid. And that sentence fits perfectly at the end of section 1. Thank you.
Ross Kinson, ROSSK and SON for Teamsters Local 533. And we sit here currently in opposition to the bill. As many of you know, Teamsters represent many warehouse workers and are in the process of trying to organize Amazon workers on a national level. And so when the Malloy decision came down, it was something that we were very well aware of. And if this current iteration of the bill goes through, what we're fearful of is that moving forward into the future, if our warehouse workers, which typically have a clean in, clean out, one entrance, one exit, and have, many of these warehouses are huge and have to wait in line to go through security screenings or, God forbid, another COVID situation, that will not be paid for time. And so we know that this is a very complicated issue. I've been on the phone with our lawyers for the last several days back and forth with both the opponents and proponents of this bill. And I really do appreciate the conversations that I've had with both sides. But I think that one of the things that I kept hearing is that we're happy to have conversation in the interim, and we're happy to explore what's going to happen with this bill. I think then if that is the case, it would be appropriate to look at some sort of a sunset moving into the next session where we can have a more proper conversation, because this is a very, very complex bill. And unfortunately, until we see that, we will remain in opposition. Thank you.
Good afternoon. My name is Aisha Goins, AESHAGOINS, Black Joy Strategies. I'm here on behalf of SCIU. I agree with my colleague here. We have been on the phone with legal, LCB legal, our own legal, and then also in dialogue. I just think this situation and this bill, the language, it's just really complicated to solve at this moment. And if there is a space where language has to be, I do also believe there should be a sunset date. So I agree with that. I'm going to read a statement. I want to make sure that we haven't talked about time. We talk about it as a concept and not a reality. So portal minutes that add up. 15 minutes and 15 minutes out is 30 minutes a day. 30 minutes times 5 is 2.5 hours, weeks unpaid. 2.5 hours at 52 weeks equals 130 hours. That's over 3 weeks of full-time pay workers lose under portal to portal. The Nevada workers at SCIU strongly oppose this bill. This bill strips workers of hard-won protections by eliminating pay for essential work activities like going through court and airline screenings. Nevada workers deserve better than federal minimums. The Supreme Court correctly recognizes our state's higher standards to protect working families. This bill appears to say, I'll say unintentionally, cut workers' pay. Unintentionally. Nevada workers and families won't go backwards. We're expecting to go forward, and I thank you for your time. And we also are available for more communication and more conversation because I do believe it's necessary. Thank you.
Gabe Christensen, Smart TD National or State Legislative Director. Have a little statement here prepared. We in rail transportation are governed by the Federal Hours of Service Act. We must report and be cognizant with what constitutes covered service under the Act in order to avoid going over established 12-hour limit. In brief, covered service would be considered any activity required by the employer performed in conjunction with our duties related to train operations. In some cases, determining what is required by the employer may relate to certain provisions of our collective bargaining agreement. It seems that in part, some of these issues with which the Chamber and the Nevada Resorts Association have expressed concern today could be better addressed in collective bargaining rather than changed to the current law. Both the Resorts Association and the Chamber have previously argued in this legislature that proposed laws should not potentially interfere with collective bargaining. It appears that Senate Bill 8, as proposed, may do exactly that, or at least set a precedent for the future for that. For this reason, I urge this body to oppose Senate Bill 8 while allowing further discussion and consideration of these matters in the current interim.
Thank you. Could you spell your name, please?
Christenson.
Sierra Martinez, CIERRAMARTINEZ. I am a local activist in the community, and I would like to strongly urge you to oppose this bill. This is not going to be protecting your normal everyday laborers that don't have a labor union behind them, and there are going to be many, this will open up many time, like we've heard previously about how time not being paid, and I urge you to oppose this bill.
Good afternoon. My name is Hannah Branch. That's HANNAHBRANCH, and I'm a policy advisor with ACLU of Nevada, testifying in opposition to SB 8. While we understand the bill's intent, this bill needs more time for review, especially related to limitations on legal action. Thank you.
Thank you, Chair and members of the committee. My name is Olivia Tanager. For the record, I'm the Executive Director of the Sierra Club Toyabe chapter. Our concern is focused specifically on Section 3 of the bill. The language in the amendment that applies to the bill's changes to any action or proceeding that is pending as of the effective date of this act, including actions where the underlying conduct occurred before the effective date. In other words, this section grants the bill retroactive effect. By striking the previous date limitation and replacing it with broad, open-ended retroactivity, SB 8 makes all currently pending actions subject to new legal standards that did not exist when those claims were filed. This is not a procedural clarification. This language would directly benefit the mining industry and other powerful extractive interests by nullifying or weakening lawsuits currently underway, lawsuits that seek to hold companies accountable for labor violations in Nevada. For the Sierra Club Toyabe chapter, this is particularly alarming. Because the mining industry and other extractive industries have a long history of environmental impacts and labor infractions in the state of Nevada. SB 8's retroactive clause threatens to strip away that accountability entirely. To be clear, wage theft will increase under this law, and workers will be required to do more work without pay under this bill, and it is a radical departure from Nevada practice. I do also want to add that we are here. I called several of my members who are out in Elko. I have members that work for the mining industry. I have members who live out in the rurals and are going to be impacted by this. Once again, we are on day 5 of session and people cannot call in. That is ridiculous and absurd. And you are circumventing democracy. We need to hear this bill during regular session. It is inappropriate to be hearing this bill without robust public input at this time. Thank you.
Thank you. And can you spell your name for the record, please?
Yes, ma'am, I can. That is Olivia Tanager, Oliviatanager. Thank you.
Michael Logan, Michael Login. I'm with AFSCME Local 4041. Pretty much the same. We're standing with our sisters and brothers in the AFL-CIO in opposition of SB 8. Thank you.
Thank you. Is there anyone else here in Carson City that wishes to testify in opposition? Okay, not seeing any, then I will open it up for neutral testimony. Is there anyone here in Carson City wishing to testify in neutral? Also, if there's anyone in Las Vegas that wishes to testify in neutral, you may come forward as well.
Good afternoon. Thank you, Madam Chair. Mr. Speaker, Madam Speaker Pro Tem, it's very unusual for Maggie Carlton, for your record, Maggie-Carlton, to be testifying in neutral. This is not a normal stance for me. I'm usually on one side of the coin or the other. Thank you so much for hearing this bill. I would like to say that the industry reached out to the Culinary Union, which I represent, 50,000 members, and we have been in conversations for the last 10 days, longer than you've been here in special session. And I've been lucky enough to be able to participate in some of those conversations. We thank the industry for being proactive in reaching out and accepting all of the concerns and addressing all of our concerns. I also need to clarify that the letter that you received from the AFL-CIO does not speak for Culinary Local 226. When folks reach out and work with us and have conversations, we're grateful for that. So I just want to make sure that when you look at that letter where it says 150,000 members, just take the 50,000 out. That does not stand for us. So, Madam Chair, thank you very much. And I'm in the building here with you, so if you ever have any questions, just come find me. I'm happy to talk with you.
Thank you so much. Not seeing anyone else approach for neutral testimony, I will ask, is Ms. Valentine back in the room? I'm sorry, I couldn't see you. Do you have a response? Yes, the whole team may come back up and approach. Do you have a response to our phone a friend?
Chair, if it's possible, I would like to provide a response.
Is your microphone on?
Apologies.
Is your microphone on?
It is on.
Okay, maybe a little closer.
Yeah, thank you. With your indulgence, we'd like to try to answer your question and also make some closing remarks if it's appropriate at this time.
It would be, because that would be the next thing.
Okay.
Assemblymember, it was your question, right? Do you want to repeat it? Because I think many of us have probably, do you remember what the question was? Okay, just so that we all, because, yes, please repeat your question.
Thank you, Chair. I think it was just a two-part question because of, gaming has moved in so many other states outside of Nevada. So my first question was, for entities in Nevada that have expanded to other states, do all of those states already follow this, if the proper terminology is portal or not? And if there are any states that do not, has the effect of that been that those gaming establishments, resorts establishments, do not offer those benefits?
Virginia Valentine. So let me try to give you some context about why this is a difficult question to answer, and then Mr. Trimmer is going to make some comments also. So there are only 15 states that have rejected or appear to have rejected the PPA. There are 18 states that have expressly adopted the PPA exception, and there are 17 states that follow the federal law but do not have any statutory or judicial decision speaking specifically to the PPA. So to answer your question requires comparing states with gaming to those states that do or don't. When you look at when gaming was legalized in other states, I mean, in Nevada, we have, as we've restating, decades of reliance on interpretation of the PPA under the FSLA. In other states, though, things are relatively newer, so it's possible that when the laws were changed or established relative to the PPA, that they didn't exist or they would absolutely comply with the law at that time. So probably whatever they were doing or practicing in those states then would comply with the laws at those times. So I think the question you're trying to get to is, was there a change in those states, and then did we make changes in reaction to those changes? And that would probably take a lot more research, but I can say that when I look at the states, when they legalize gaming, and I will mention too here that operations in other states may not look like a resort hotel like they do here. I think we have, I want to say 12 of the 20 largest hotels in the world here. So in another state, you may have 200 hotel rooms. I mean, it may be a completely different dynamic. So it makes this a very difficult comparison to make. And with that, I think my colleague, if it's okay with unless you have more questions for me, Mr. Trimmer can add to that.
Thank you. Paul Trimmer for the Resort Association. As Ms. Valentine said, it's difficult to compare what has just happened in Nevada to any other jurisdiction in which gaming employers operate. The only direct comparison is in terms of how the law just dramatically changed. And I respect the opinion of those who spoke just a little bit ago, saying that this somehow diminishes employee rights. I couldn't disagree more with that, because that view that this change somehow or that the amendment that we're proposing somehow reduces employee rights is based on a false premise. It's based on a false premise that Nevada has done anything other than rely upon federal law as a baseline. And although I respect the Supreme Court in its decision, the analysis that it employed in Malloy led to a result that led us here today, that has violated the reliance interests that the resorts in Las Vegas and the rest of the state have had in consistent law for 50 years. So as I said, the only state...
Excuse me.
Yeah.
Are you still in your response to her question?
Yes,
Okay,
I'm sorry.
Continue, please.
So the only state that has gone through something comparable that I'm aware of is Pennsylvania. Pennsylvania rejected the Portal to Portal Act in a very similar way in 2024. I'm not aware of I've not worked with any employers that operate as gaming employers in Pennsylvania. Anecdotally, and also looking at law review articles and legal publications, the amount of litigation in Pennsylvania that has taken place since that rejection has skyrocketed, because that state didn't have guidance, it didn't have court decisions or regulatory guidance on how employers could comply with the law. And I would submit that Nevada is in the same boat. So we're in a situation where we have very, very little state Supreme Court guidance and very little labor commissioner guidance, because in general, that has never been needed. So I know that that's not a complete answer to your question, but it's an answer because the situation we're finding ourselves in isn't comparable to any other state in which resorts operate. The last thing I could say is that, and this is again, as Ms. Valentine explained, when you compare the operations of resorts in other jurisdictions to those in Las Vegas, and this is anecdotal, the best thing I can say is that the town square feel that you have when you're in the back of the house of a hotel in Las Vegas, that doesn't exist elsewhere. The freedom of access to the back of the house, the use of facilities, the robust nature of the facilities in the back of the house in Las Vegas, that does not exist in other jurisdictions where most gaming operators operate. That's the best answer I can give. I wish I could give a more detailed answer, but that's what I know.
Thank you so much. I honestly did not think that my question was going to take this amount of time to answer. So I appreciate the time that you took, but your last statement stating, and I'm not sure if your last statement was an answer, because you said anecdotally, other states don't have the benefits. So I just want to make sure that you said that as an anecdotal, then that wasn't a statement answering my question.
It's anecdotal.
Okay.
That's the best I can say. To do a comprehensive, to feel comfortable that I was giving you a comprehensive answer the way that you're question asked for. Haven't had time, and I wouldn't be able to do that. But I can give you an anecdotal answer, and then also explain, as I said, that this situation is not comparable to any other state where resorts operate.
Thank you. And I appreciate you returning to respond to that question. And for those that are here or watching, I know it may seem a little unorthodox to return to questioning, but we rarely have an opportunity where that question was able to get the answer and we were notified of that response while we're still in the hearing. Often what happens is it can sometimes even be a few days later where people that had questions that we requested, they submitted in writing to the committee even a few days later. So I appreciate that we had the opportunity, and thank you so much for your due diligence to work to get that response immediately. So thank you for that. With that, questioning is closed again, and I will welcome the presenters up for any final remarks.
Okay, go. Madam Chair, for the record, Paul Moran from the Vegas Chamber. Sorry. I just want to clarify and appreciate the conversation we've had today, and thank you for your indulgence, Chair. As you've heard, this is a concern, and you've heard from multiple trade associations and other chambers, the concern across Nevada, and that is why this bill has been brought forward to you today. I also want to restate that commitment that the Chamber has made and our trade partners is with the most sincere integrity that we will. And we will follow up with Assembly members that suggested that, and we will work convening trade partners and labor groups to have that conversation and potential BDR, what that bill could look like for a future session. But I also want to add one quick perspective. I work for the Vegas Chamber. I am an employee. Why would I advocate something that could protect me? So, I mean, why would I want to do something that's going to hurt me potentially? So just to add that perspective, I'm an employee also. I'm also a former public employee. I would not advocate something that hurt my personal rights. So just add that perspective today. Thank you.
Virginia Valentine, and I too want to thank the committee for your indulgence. This is, if this was not such an important issue, we would not be bringing it to a special session. We've had about 2 weeks to get our heads around this decision. It did come, as Mr. Chairman said, as a shock to us all. I also want to thank Maggie Carlton. I really appreciate her working with us and the entire Culinary Union for their work with us. Not just today, but every day. They make it possible to have world-class destination resorts. I also want to reiterate our commitment to working with all of you, especially Assemblywoman Karras, on the 2027 legislation. I really appreciate your support, asking for your support. I think we've tried to make a point here that the consequences of not taking action today are pretty dire for us, and so we would urge your support of this bill. And again, thank you all for your time.
Paul Trimmer for the Resort Association. Thank you again for your time and for allowing me to answer all of your questions and give as full of a response as I'm capable of giving. I wanted to close by underscoring one of the points I made, which was that the decision in Malloy was a huge surprise. And I think the best way to highlight how much of a surprise it was is by citing and referring you to a prior Nevada Supreme Court decision that was issued in 2015. It was called Rite of Passage. And Mr. Esposito was speaking earlier in opposition to the bill, and one of the things that he had concerns about were activities that he believed would constitute work, and that the regulations, adopting federal law, doesn't necessarily compensate employees for situations where they're acting under the direction and control of their employer. And so again, in a Supreme Court case, the Nevada Supreme Court case issued in 2015, called Rite of Passage versus the Labor Commissioner, the Nevada Supreme Court adopted the federal regulation, or referenced and relied upon the federal regulations and the federal definition of work. It concluded, and it's important to note that it was referring to an old Supreme Court case that's also referenced in section 790.4 of the Portal Act. Again, and here's the definition of work that the Nevada Supreme Court adopted at that time. Let me find it. It's It means physical or mental exertion, whether burdensome or not, controlled or required by the employer and pursued necessarily and primarily for the benefit of the employer and his business. And that was citing to a Supreme Court decision from 1944. Now, it's important to note that the manner in which that definition of work was applied is what led to the Portal to Portal Act, to ensure that the direction and control aspect couldn't be expanded to require compensation for everything under the sun, but instead was considered as a factor in compensability, which is what the Portal to Portal Act does. And I would suggest that adopting this this multi-factor test that's in federal law now, continuing to rely upon it, and then committing to working on this legislation over the next couple of years to get whatever Nevada-specific changes need to be made is the appropriate solution, as opposed to exposing employers to existential liability for violations they didn't know that they had committed, relying on, among other things, old Nevada Supreme Court decisions which instructed us that we should rely on federal law when it comes to the definition of work. I don't know how any other way to make it more clear that this decision disturbed and upset a consistent approach that our industry and other businesses in Nevada have relied upon for decades.
Thank you so much. And with that, I will go ahead and close the hearing on Senate Bill 8. Next on our agenda is public comment. So public comment is an opportunity for the public to come forward and make any comments that they wish that are under the purview of this committee, but not related to the bill that we just heard. So the same process, I ask that you state your name and that you spell it for the record and any affiliation you may have. And also, you will still have 2 minutes. So this as well, is there anyone in Las Vegas that would also like to come forward? Not seeing anyone. Anyone here in Carson City wishing to make public comment, please come forward. And again, this is not, public comment is not in relation to the bills heard today. So with that, please proceed.
Thank you, Chair and members of the committee. My name is Olivia Tanager. For the record, I'm speaking currently on behalf of myself as Olivia Tanager, not on behalf of my organization. I just want to state that the fact that we are on day 5 of special session, that this committee is not allowing phone-in testimony, that nobody in the assembly is allowing phone-in testimony, is a disgrace to this body. The fact that we don't have translators available for people to comment in Spanish is a disgrace to this body. The fact that this special session was called to address corporate interests instead of the needs of working-class Nevadans is a disgrace to this body. The fact that we have people being kidnapped off the streets and we are not adequately addressing that in this special session is a disgrace to this body. The fact that people cannot keep their utility bills on and we are not addressing that in this special session is a disgrace to this body. And that is what I want to say. And I have been getting calls from my members. I've been getting calls from community members who want to participate in the special session and have been unable to. I think you all know that the bills that you are pushing forward are not popular with the public. And yet we are here wasting $100,000 a day to address these issues instead of addressing the issues that your constituents are begging you to address. Please reconsider the way that you are prioritizing issues going forward. Thank you.
Thank you so much.
My name is Aisha Goins. I am standing as a constituent, and I wanted to just say thank you for the life and memory of Nurse Julie. She's a Canna nurse, and she dedicated so much of her time to moving policies forward for those persons who needed medical cannabis. And she passed away in the last week, and I just wanted her name to be on the record and for her memory to not have been for naught. And so thank you.
Thank you so much for that, and we offer our regards and respect. Anyone else here in Carson City that would like to make public comment? Not seeing anyone here or in Las Vegas, I will go ahead and close public comment. With that, thank you, members, so much for your attention and work. Everyone who participated in this hearing today. Right now, we are going into recess. Hello, everyone. I will call this meeting back to order. I would first like to acknowledge that Speaker Yeager and Assemblymember Gurr are absent excused. And with that, we will go into our work session. So I will hand it over to our committee policy analyst to explain the work session document.
Thank you, Chair. For the record, Cesar McGraw, Committee Policy Analyst. As a nonpartisan LCB staff, I can neither support nor oppose any of the measures that come before this committee. And the bill on work session today is Senate Bill 8, which revises provisions relating to employment and was sponsored by Senate Select Committee on Jobs and Economy. This bill was heard today, and there was an amendment proposed after today's hearing. It's proposed by Assemblymember Marzola, which is to add language to provide that the provisions of Section 1 expire on October 31, 2029, unless extended. And amendment number 2 is to amend Section 3 to provide that the bill's provisions continue to apply until the bill is rendered ineffective if applicable. And Chair, that's all the amendments.
Thank you so much. Members, any questions? Not seeing any, I will entertain a motion to amend and do pass. So moved. I have a motion by Vice Chair Marzola. Do I have a second? I have a second from Assemblymember Cole. With that, are there any additional questions or comments? Okay, I will start with Assemblymember Roth.
Thank you, Chair, and I just want to say thank you to all the stakeholders who came together, and especially our Speaker Pro Tem Marzola for doing the work on this. I will be voting it out of committee, and I just want to see the language before, so I reserve my right on the floor.
Thank you. Assemblywoman Moore.
Thank you, Chair, and I just want to say ditto to what Assemblymember Roth said. I will be voting yes out of committee, but reserve my right to vote no on the floor.
Assemblywoman Gonzalez.
Ditto. Thank you, Chair.
Members, any additional questions or comments? Not seeing any. All those in favor, please say aye. Aye. Anyone opposed? And the motion passes unanimously. I will sign that floor statement to Vice Chair Marzola. With that,
Thank you, Chair.
You're welcome. Thank you, committee members, for your intensity through the hearing. Thank you for everyone that participated, whether presenting or testifying. With that, that concludes our business for today. As you know, just pay attention to see what's going to happen tomorrow. But with that, we are adjourned.